Ladies and gentlemen, boys and girls, welcome to my channel, Audit the Bar or Exposing Bar Secrets, whichever you prefer. My name is Trent, I'm your host. In case you're not aware, I'm a person who has lost his license to practice law in the state of Florida for no valid reason whatsoever, except maybe revenge, whistleblower retaliation, things of that nature. So I decided that I'm going to publicize a very secretive process. I'm going to expose the mechanisms of this nasty institution. We're going to audit the Florida bar. The way I've chosen to do that is to send in 4 bar complaints, or more precisely, 3 bar complaints and 1 complaint to the Judicial Qualifications Commission against the referee, which is sort of like the judge, in a Florida bar disciplinary proceeding. And this person was appointed to be the referee over both my original disciplinary case and my reinstatement case. Oh yes, that's a whole separate court case that you have to go through. Even though, by rule, I was entitled to have that in my home district of Broward County. And they put it way up there in North Palm Beach County with the outgoing president of the Florida bar's husband as my referee, and her pretty much best friend, head co-prosecutor of lawyers across the state of Florida for the 15 years immediately preceding that, is my antagonist, Adria Quintella. I noticed something weird though, right as I was dropping this JQC complaint in the mail and having a mental masturbation about what amazing video I'm going to make regarding it now that I've finally sent it out, and they can't put a stop to it by killing me. Hopefully that lessens those chances somewhat. But it said on there that JQC complaints are confidential. What? Why on earth would they be? Aren't we about sunshine government? Aren't we about open government? Is that even a debate? Is there even a minority anymore that says we don't need open government? Cameras everywhere. That's what I'm saying, ladies and gentlemen. I mean, they have these obsolete rules like you have to use court reporters and you can't record the court proceedings. Why not? They should all be free to be recorded by everyone. And, yeah, of course they want it confidential because they don't want the public to make an outcry or to get interested in somebody's JQC complaint, because then the public might become aware that it's a joke, that basically the complainant gets railroaded and all deference is given to the judge. Same thing with the vast majority of police internal affairs investigations. If we've learned one thing in the USA after 244 years of democracy, it should be that self-policing won't work, bro. Pro probably didn't come about till the 1970s, but you know what I mean. So I just like to, lessen up the formality of my language occasionally. Hope you don't mind. Yes, and I'm not politically correct, so if that's the channel you're looking for, GTFO. All right, so with my technologically impaired self, I'm going to try now to actually show you my screen. This would be, if I were competent or practiced in this particular task, I would know how now to switch you to my computer screen. Bet you I can do it. Alright, so here we have disclaimer, that's not Bank of America, it's actually Skank of America. What I'm going to do is go on down here to my complaint. State of Florida Judicial Qualifications Commission complaint against a judge. It says somewhere, oh yeah. Confidential. You will be notified in writing of the outcome of your complaint subject to the limits of confidentiality? Huh? Oh no, we're not abiding by that. If there is confidentiality, it should be to protect me, and I'm going to go ahead and waive it. See complaint and exhibits. See attached. May 11, 2024. Oh. somewhere in here, there's a, anyway. Complaint against Judge Scott Suskauer. Introduction. Judge Scott Sauer was the referee, Scott Sauer, that's a good name for him, was the referee in a Florida bar disciplinary proceeding against me as well as in my subsequent action for reinstatement. The misconduct of Judge Suskauer, of which I complain, falls mostly within three categories. First, there is Judge Suskauer's failure to recuse himself. Second, Judge Suskauer took the bench while impaired and appears to have a substance abuse problem in the form of a dependency or addiction to opioids. Third, Judge Suskauer violated the Code of Judicial Conduct in the preparation and execution of the report and recommendations, denying my petition for reinstatement. Judge Suskauer was required to disqualify himself. The underlying litigation was the Florida Bar versus Kenneth Eric Trent, case number SC 19342, hereinafter the disciplinary case, followed by a reinstatement proceeding, SC 23-89. 15th Judicial Circuit Judge Scott Suskauer, whose wife was the president of the Florida Bar, was somehow appointed as referee in both cases, even though by bar rules, I was entitled to have the case heard in my own district, the 17th, Broward. Rules regulating the Florida Bar 3-7.6d governs venue in bar proceedings. The venue. The trial must be held in the county in which an alleged offense occurred or in the county where the respondent resides or practices law or last practiced law in Florida, whichever is designated by the Supreme Court of Florida, provided, however, that if the respondent is not a resident of Florida, and a bunch of other irrelevant shit after that. One of my strategies in the case was to introduce evidence tending to show that the bar's prosecution was politically motivated and a case of whistleblower retaliation. The central figure in that defense is Adria Quintella. A June 11, 2015 Florida Bar podcast described her like this. Adria Quintella is staff counsel and director of lawyer regulation for the Florida Bar. She supervises the operations of the entire lawyer regulation department of the Florida Bar, including direct supervision of the chief branch discipline counsel in each of the 5 branch offices of the department. She has been with the Florida Bar for 19 years. Department of Redundancy Department. Adria Quintella signed the Florida Bar's complaint against me in the disciplinary case. Part of my theory was that she brought the case to retaliate against me for my conduct in conjunction with the bar complaint I filed back in 2010 against the now infamous foreclosure king David J. Stern. My first trial exhibit was my December 28, 2011 letter to Quintella attempting to follow up on that complaint. In the letter, which is enclosed herewith as Exhibit A, I criticized the bar and Miss Quintella's office for allowing David Stern's firm to continue in operations for many months after I gave them all the evidence they could have ever needed to file a petition for emergency disciplinary suspension. Let's take a look now at my letter from December 28, 2011. You can read the heading, the addressee. Dear Miss Quintella, I feel professionally obligated to write to you. Well, let's check the date here. December 28, 2011. I feel professionally obligated to write to you. David Stern has committed a massive fraud on the entire Florida court system and thus far has largely gotten away with it. Although the subject of national news articles suggesting he is likely to be criminally tried for these exact same practices, he maintains good standing with the bar. What is going on here? Several people appear not to be doing their jobs. I am simply floored that the bar has taken no action on TFB file number 2011-50216 or on any other file numbers that may have been associated with my grievance against Stern, lodged in September of 2010, and complaining of the wholesale production and filing of fraudulent assignments and false affidavits in thousands of recent foreclosure cases with particular substantiated examples. Why don't I use a run-on sentence occasionally? How does he still have a license? You know me, I would think, as a polite and competent member of the bar, and I certainly respect you and your staff based upon my prior dealings with you. The tone of this letter is compelled by the circumstances, as I hope you can understand. For ease of reference, I include 6 pages of material submitted in support of the grievance several months ago. I intend to pursue this matter further should I not hear from you with something concrete in the near future. If this matter is not your responsibility, I'm sure you will direct me as to whom I should address this serious concern. Warm holiday wishes, and I do look forward to speaking with you soon. And then, now if I could possibly switch back to the video capture. So the deal with that was, guys, I filed a complaint against David Stern, who's now been disbarred, was the subject of many national news articles, basically run out of town in disgrace, you know. And I was one of the very first people to come after him with the Florida bar because I was a young, naive lawyer and I respected the Florida bar. And I thought that I was obligated when I knew that a lawyer was engaged in ongoing criminal conduct week after week after week right in front of my face. I thought I had no choice but to report him to the Florida bar. And can you imagine, even though I knew, young lawyers, even this one, a very naive one, knew it's really not a good idea to bring the bar's attention on myself, But I went ahead and took that chance. I thought they really can't be that big of ogres. They really can't be that bad. Surely they're not going to come after me. I'm totally an angel in this situation compared to the guy I'm talking about. And then I wanted to just stop there, I guess, since I forgot what I was going to say next. But this bar complaint, my text version of it, is, my typed out pages are 14, but it's slightly larger font than usual. And then I think I had about 68 pages of exhibits. There's many other things I'm complaining about. Now, that might seem harsh to accuse the man of opioid addiction, and that's just my opinion. I don't have proof of that. I don't know it for a fact. I'm not a fly on the wall in his bedroom or bathroom or vehicle or wherever he does it. But, I have many good reasons to believe it. And as I will show you, and as I recounted in my complaint to the JQC, there are certain well-known symptoms of opioid abuse, which he manifested repeatedly throughout the alleged trial. He couldn't hear, he couldn't focus, he was very confused. He went off on me for a page and a half because I called an attorney a flamethrower, which was actually a compliment. Obviously, he said I was trashing her by saying that. He would constantly say, not constantly, but every 5 or 10 minutes he would say, "One moment," for no apparent reason. So we'd be right in the middle of a question, right in the middle of testimony, right in the middle of argument, and right in the middle of a train of thought, and he would say "one moment" and then just sit there. "Okay, you may proceed." And it would be like, "All right, I'd like you to look at the bar's Exhibit 1. The judge is like, "What exhibit number?" "Exhibit 1. Page 1? "No, Exhibit 1, Judge." That kind of stuff. So, I don't make those accusations lightly, but why should I be nice, any nicer than, I have to be? Because the man obviously didn't have any sympathy or any empathy for me, despite the fact that I'm clearly a good person, clearly a lawyer with integrity, clearly didn't deserve to be suspended in the first place. He didn't give a damn, You'll see, we're going to go through the transcript of my disciplinary proceeding, just as I did with the JQC. And it's kind of like if it wasn't so funny, it would be tragic. So it should be interesting to see how this all comes out. Don't you agree? Anyway, I'm Trent. This is a channel called Audit the Bar or Exposing Bar Secrets, whichever. Please pass this on to your friends because it's only going to get better from here. Thank you. God bless.